So my name's James. I'm from Community Legal Centres Queensland and delighted to be introducing Meredith Bennett, who's a partner from Ashurst, to talk to us today about helping clients recover debts. Can I begin the section by acknowledging the traditional owners of the lands on which we're dispersed? So here in Brisbane, where we're speaking from, we're on the land of the Turrbal and the Yagara people, and so we acknowledge their continuing custodianship of this land. We do have people joining us from across Queensland. In fact, I think there's a few from other parts of the country as well. So we pay our respects to elders, ancestors, emerging leaders, and any Aboriginal and Torres Strait Islander people who have joined us today. Before I hand over to Meredith, just a few housekeeping things. Firstly, I should probably do a bit of a disclaimery kind of thing. Meredith's prepared this on the basis that the audience is community legal centres here in Queensland. So we're talking about some of the forums and some of the processes here in Queensland. I know that there are people who have joined in from other parts of the country though, so please do bear that in mind. There are a couple of ways that you can ask questions in this webinar process. You can type a question into the questions box. We'll see a question pop up on our screen and we'll read it or paraphrase it or something, and Meredith can answer the question directly. The other way that you can ask a question is to press that button that looks like a hand on your control panel, and we'll see something go up at our end. We'll be able to unmute your microphone and you'll be able to ask a question directly. We might ask you to hold your questions over until the end though. Webinars aren't a really great format for too much toing and froing. If you do have an urgent, can't wait question, feel free to throw it in there. Otherwise, please note it down and we'll make sure that there's plenty of questions time at the end. Hoping to have a recording of this webinar available, and we'll provide a link to that if the technology works. Have also provided a link to everyone who'd registered as of a couple of hours ago to Meredith's PowerPoint presentation. You should be able to download a copy of the PowerPoint presentation from the handouts area on your control panel there as well. I think that takes care of those boring housekeeping things. On to the much more exciting substantive content that we're talking about today. Often in community legal centres, people come and see us. They're owed money and they want to understand what their legal rights are in terms of having that money returned to them. And so we reached out to Meredith and her colleagues who very generously agreed to present today on helping clients recover debts. Meredith, as your screen suggests there, is a partner in the disputes section of Ashurst and has also worked in insolvency and has a fair bit of experience in this kind of stuff. So really delighted to welcome Meredith Bennett to speak to us today about helping clients recover debts.
Thanks very much, James. Look, the whole essence of this presentation hopefully will cover both some of the legal points, but more so will be a practical guide to the things you should really consider when advising your clients. And I've focused on particularly what to consider before you even start the process, because often clients come in quite emotional about debts owed to them, and as you go down the track you might find out things that mean the debt isn't as high as you thought, or there's set-off claims, or it's more convoluted, or sadly, as often the case is, getting a judgment and winning in inverted commas doesn't necessarily equal the recovery that comes back. So that's why I wanted to sort of focus on, that yes, there are methods, but also the various risks and perhaps the various other options you can take. I note from James, as I said, this seminar is Queensland focused, but in terms of the Magistrates Court and QCAT, there are obviously identical both tribunals in the other states, and obviously we also cover the more national ideas of statutory demands and bankruptcy notices, all of which are applicable across Australia. Okay, so what we'll cover is what to consider before you even start a debt collection process. Secondly, letters of demand. I think letters of demands are an incredibly important part of this whole sort of process. They're often the first sort of significant piece of correspondence you might help a client draft. They might have already done one themselves, but often it's at that point you might want to clean up and cleanse the process by drafting a proper demand letter. And also letters of demand generally are what forms the basis of any statement of claim, and they'll certainly end up before the court and in front of a judge's eyes. So that's why it's particularly important to get those right. We'll look at commencing proceedings, obviously in the Magistrates Court, and also QCAT, or in Victoria VCAT, which I've had the misfortune sometimes of spending lots of time there. I will say, again, I focused on Magistrates Court and QCAT because I'm thinking that the majority of clients that you deal with are probably not owed in the hundreds of thousands. It's probably more 100,000 and below. We'll also look at statutory demands and bankruptcy notices. And then I'm going to also have a quick moment on alternative ways of resolving disputes through ADR. Also talk about debt collection agencies and how to go about sort of advising your clients whether they're worth engaging or not. There are some fear around these agencies, but actually a lot of them do a very good job at recovery, but there are sort of risks involved in sort of handing over a claim to a third party. And I thought it'd be worth it to talk about, well, what happens if you actually do get an agreement out of the other side? And we're talking about settlement and a quick refresher on how to draft a good deed of release to make sure that, you know, the money's paid back and that's the end of the matter. And obviously I've left some time at the end for questions. What's a quick way of doing that? I always just do it that way. So someone comes in, what to consider? Well, the first thing is to whom the debt is owed, and secondly, who is it debt? Is it a company or an individual that owes the debt? Now, this is important. It might sound like a simple question, but obviously, if a company owes a debt, there are options such as statutory demands. These are not open if it's an individual that owes a debt. Similarly, a bankruptcy notice can't be issued to a company, but can be issued to an individual or a partner. Also, it does also mean that even if you do get a judgment later on, what are your options? With an individual, you have the options of sort of garnishing of wages or sale and seizure of assets. If it's a company, you're more likely to go down the liquidation route. So it is important to understand pretty soon on, is the debt owed by a company or an individual or even a partnership or a sole trader? And again, there are sort of separate options in relation to each type of entity. So that's a pretty good and important primary question. It might also be that the debt is jointly owed between an individual and a company, and they're important points when you come to pleading out your statement of claim. Again, how much is the debt? There are certainly limits, as you'd all be aware of, in both in QCAT and the Magistrates Court, Supreme Courts and District Court. They've all got their jurisdictional limits. And again, for bankruptcy notices and statutory demands, the limit's 5,000. So again, it sort of will mean that pretty early on, if you know how much the debt is, you'll be able to determine what are the actual options available to your client. And perhaps often clients think there are options for bankrupting people when they're owed about $500. So it's pretty good to quickly dissuade them of that idea and go, well, look, for that amount of money, here's your options in terms of recovery. How did the debt arise? Is it an agreement? Is it a consumer service provider relationship? That's important for things such as terms of consumer and service. That means you can go off to QCAT. What documentation do you have in support of the debt? Is it an agreement? What are the terms? Are there terms in there where someone should have alerted them? If the agreement is verbal, which often is the case, it is really important to scrutinise in a supportive way your client earlier rather than later. And certainly I've dealt with a lot of oral agreements, and the problem with that is you really need to know exactly what was said, what were the terms, especially in terms of money being lent. Was the understanding that it was a gift? Was it understanding that the money would be repaid immediately or upon demand? Just because it is verbal doesn't mean your client doesn't have a case, but you're really going to need to know particulars of what was agreed as opposed to maybe implied or understood, because that can cause problems later on. In that regard, really important to get as much documentation from your client as possible, particularly if the agreement was verbal. And that means there may not be a nice little email that sort of says, further to what we discussed today, is, you know, I'm going to lend you $5,000, but there might be other emails that allude to the money being owed. There might be text messages, handwritten notes, anything that can even pre or even post an agreement being formed, because post, you know, correspondence can support your client's argument that there was a verbal agreement, particularly if there's a line of text messages that say, hey mate, when are you going to pay me back? Remember you said it would be in March. So anything like that that can support your client's claim is really important to get earlier rather than later. Now, could there be any counterclaim or set-off raised? And this is something clients don't often consider. There may be money being owed in two different directions, and I've certainly had a case where someone was very much clear that a gentleman owed them money, a certain amount of money, and it was sort of 6 months into sort of acting for them where the other side raised the fact that there was money owed the other way. My client's reaction was, oh, I didn't think I need to tell you about that because that's a separate deal. That's about a car. That's not about this. But the reality is you need to know about any type of arguments that could be raised in that kind of counterclaim or set-off manner, because again, that'll inform about how complicated the dispute might be. And in terms of issuing things like statutory demands, it may mean that actually isn't an open option for you because it's more likely to be subject to a genuine dispute, and that won't be a correct format to use. So that's why it's really important to get a clear idea whether there might be any arguments coming back. Also, obviously, set-offs are important in terms of if there is money owed the other way, it will obviously reduce the total amount owing if there is mutuality between those debts. Really important to be realistic about recovery sooner rather than later. And that's hard to do when a client is convinced that someone does have the means to pay them back. But there are searches, and this sort of dovetails into my next point about there are searches to conduct in relation to a debtor that's often useful to do sooner rather than later. And they are, and I understand they can be an expense. It can be sort of, a couple of searches under about $100 to do, but you can certainly do a property search, see if the debtor owns property. That's sort of your first one, because if they own property, you think they'd have some means. Always really important to do a bankruptcy check before you even start. It's amazing how many times people don't know someone's already been bankrupted and they start a proceeding because you just don't know these things. It's not publicly available. You need to do an actual search. So you commence your Magistrates Court claim and you've spent the money and your client spent the time and emotion, and it turns out the person's already a bankrupt. In that circumstances, they can still prove, as it's called, in their estate, but you're not going to continue on your proceeding unless you get leave of a court, and there'd be little use in those circumstances to proceed. So it's a simple check that should be done, particularly if someone is owed a small amount of money, because it's a probably good sign if they can't pay back your client, they may also not be able to pay back other people. Again, if it's a company, particularly a small company that owes money, good idea to do a company search. It will also throw up whether there is current petitions on foot to wind it up. So the company might still be registered, but if you look at the search, if you are in the process of winding a company up, that should be noted on there as well. So you'll be able to say to your client in those circumstances, look, there already is someone else who's trying to wind this company up. It should say the name of the solicitors who's acting or the person. You can actually then contact that other creditor and say, hey mate, when's that before the court? And then go along to court and look, the job might be done for you. So it's a quick way of, finding out and saving your client the expense and hassle of having to, say, wind up a company when someone else has already done so. And lastly, is the debtor represented? And obviously this is something to keep an eye on as you go along. Certainly the debtor may not be represented to start with, but we've had to dissuade particularly some of our pro bono clients from overly harassing a debtor. There are laws, obviously privacy laws and harassment laws. Some people get pretty emotional. And if a debtor does become represented, even by a friend or a family, or they say, look, don't contact me, contact the third party, it's pretty important critically to dissuade your client from perhaps contacting them directly, because that can muddy the waters quite a bit. So that's a sort of checklist of what to consider before you even start the debt collection process. Okay, so your first thing you want to do, even if your client does say that they've tried to call them and maybe they've sent their own letters, is probably send a good, clear letter of demand. And the good thing about sending a good, clear one is that this can basically be your first pleading in any statement of claim. You don't necessarily need to plead any other attempts by your client, probably preliminary attempts to get the money back. You can probably kick off your statement of claim with a strong letter of a demand. So it should follow attempts to contact the debtor by way of reminder. And look, as we all know, relationships break down. So if you're now in charge, it might be best that you then attempt to contact the debtor. They may have just been avoiding your client's calls. So if you have obviously this letter should follow some attempt, even if it's just one or two, or some other reminder. If possible, and this is not like a prescribed list, there is no right answer in terms of letters of demand, but this is certainly some of the things I think would be helpful to include, is refer to any previous correspondence. Obviously keep to correspondence that was sort of correct in the first instance. Set out precisely, but in a summary way, the debt is owed. So if it is an agreement, even if it's a verbal agreement, it's good to say, pursuant to an agreement on or about X date, this amount of money was owed. Clearly state how much the debt is, why the debt is due and outstanding. And this is important to understand the terms of the agreement, because it may not be that the amount is due and outstanding yet. So if your client had an agreement for someone to pay them back in December, then it's going to be difficult for them to suddenly start demanding it early in that time. But if the understanding was that it was payable on demand, then that should be stated clearly. The term of this agreement was that it was payable on demand. Accordingly, we demand now the following sum to be paid. A period of time for the debt to be repaid. Obviously, there are some instances where it's immediately due and payable, but I mean, even when dealing with banks, and I act for a lot of banks, it's always wise to give people a decent period of time, at least 7 days. Now, again, there's no law about this. You can say pay within 24 hours, but there is a benefit in terms of looking reasonable later on before the court, and giving, a period of at least 7 days, for example, is a good idea. Also, it is good to state the consequences of not paying within the time frame. Some people might find this a bit aggressive in the first instance. So the other option is you can reserve all your rights. So you say, if you do not pay within this period of time, our client reserves all rights to pursue further recovery action. Or alternatively, if you want to be clear, then state the consequences, and that could actually be the prompter for someone to make sure that they pay back the debt. So if you do not pay in time, our client reserves all rights to take steps, including commencing court proceedings against you to recover the debt, plus interest and costs. So if you think that your client would be entitled to interest and costs, then state it in this letter of demand. And I put just a reminder, this document, will end up before the court and be in evidence. So over-inflammatory or aggressive or threatening language should be avoided. I mean, letters of demand in itself, when they say, we demand you pay and we will sue you, are in itself, aggressive enough. That doesn't need too much more flowery language than that, and I'd resist that. Also, try to encourage your client not to overreach. What I mean by there is, if often there are multiple debts owed, or your client believes that there might be multiple circumstances where debts owed, but you think maybe 3 sound very shaky and 2 don't, it might be best to kind of, subject to your client's instructions, is just to demand the debt that's clearly due and owing, that there's good terms around. And this means you're more likely to be able to, perhaps if you do commence proceeding in a magistrates court, the other side will be stripped of any defences they could have, and your pathway to, say, a summary judgment will be a lot quicker than if you sort of plead all these different debts and then the other side raises very good defences, and all of a sudden you're stuck in a dispute, which if you had sort of dropped maybe the less convincing points, you'd be in a better position. Obviously, consider enclosing relevant supporting documentation. So if there's invoices, or perhaps in the terms of an oral agreement, if it's sort of a debt of $1,000 and perhaps there was an email exchange between the parties, there's no harm, they're not privileged, if they're not privileged, which they shouldn't be, there's no harm in enclosing those emails and saying, look, this evidence is clear evidence of the agreement, just to give supporting evidence. Keep a copy of any original documents, and obviously keep a copy of the signed letter of demand, and check with your client whether they do have up-to-date address details for the debtors. Often people move around and they might have said they've sent them 4 letters before, but it turns out those letters are just sitting in a box of some person that moved out 5 years ago. The other thing is, consider several methods of service. There's no harm if there's an email and an address to what we to go to the scattergun approach, and we certainly always do that with our letters of demand, and at least this way you know that they've hopefully received them. So commencing proceedings, QCAT. So if this is really managed, QCAT has I can't remember how many years ago now, but this used to be, all minor debts used to be handled by the Magistrates Court, and then QCAT, under the legislative change, took on the minor debt, or what used to be called the small claims process. So they have the minor debt dispute process. It's open to individuals, businesses and traders. Now the debt must be no more than $25,000, so if it's any more than that, you're out of QCAT. The cause of action has to have arisen in Queensland. Again, I will say, from my knowledge of certainly VCAT, it's very similar rules around the jurisdictional limits and the type of disputes QCAT or VCAT or the New South Wales equivalent will deal with. Has to be liquidated debt, so it can't be a claim for, say, damages, or clear terms of agreement for money to be paid, which means there can't be it can't be an equitable claim or anything more sort of in the complex realm. You can't use QCAT if there's no previous agreement. The debt is for the repair of a defect of a motor vehicle. The debt is for damage to property caused by a motor vehicle, and unpaid wages. We often have clients, or certainly in our pro bono clinics, coming in about sort of work, perhaps not in a formal employee-employer sense, but they'll say, you know, they did something for someone, they chopped down their trees and they're going to pay them a wage. This will be more likely covered by the Fair Work Act. I will say the tribunals are pretty strict with their jurisdictions. They don't like to be, I'm sounding a bit overly critical of the tribunals, but they don't like to do anything that's outside of the sort of square. I will say QCAT can be unpredictable. So if there is an element of complexity to your dispute, or perhaps a set-off or a counterclaim, or perhaps maybe when you look into it more, it really is a claim for damages, then I'd probably steer clear of using the tribunal. But it is a great quick process certainly for simple debt disputes, good ones for traders. So the classic is tradie coming to debts owed for work done by somebody, or someone did do work for someone and they didn't pay. Maybe your client is a tradie and they have never been paid. So a great way of sort of resolving those type of, or neighbourhood disputes, all those type of ones via QCAT. Stop doing that. There we go. The process for QCAT is pretty... Yep.
In relation to the purchase of a vehicle which has a defect, needs to be dealt with in consumer and trade dispute in QCAT, claiming value of work done since purchase using the ACL, breach of contract arguments.
Yeah, purchase of a vehicle. Yep. So I've just got a question in which was said, in relation to the purchase of vehicles which have a defect, can this be dealt with as a consumer and trader dispute in QCAT, and thus claiming value of work done since the purchase using Australian consumer law and breach of contract arguments? I believe the purchase of a vehicle with a defect would probably fall within QCAT. The complexity around the value might be your issue. So it'd be more in the remedy that you're claiming, which might force it out of QCAT's realm, rather than the actual way the dispute arises.
Sorry, I might just jump
in. Yeah.
We made a submission to the Queensland Parliament inquiry into lemon laws for new cars, which identified some of the gaps in consumer protections for purchases of new cars under this kind of regime. There's a review of the Australian consumer law happening at the moment. It's certainly on their agenda to be looking at stronger protections for purchases of new vehicles.
With the view that those type of disputes should end up in QCAT? Yeah, because they're the right.
Under the ACL,
yeah.
Protections in place, which ordinarily would go to QCAT, but who knows whether the review will land on that.
So the process, just quickly, I'm sure you're all familiar with QCAT. It's an application, not a claim and statement of claim. The debtor has to put a response in within 28 days. Then the parties are given a notice to attend mediation. This is often a really good opportunity to try and get a resolution. You may not, it's a classic thing, you may not get all the debt offered to you, but you know, this is that opportunity to go, well, fast money is good money. Certainly, that's what I advise my clients to a certain degree. I mean, you know, don't want to be overly compromising if their case is strong, but if someone is offering money, then certainly it is a good opportunity to perhaps get a deed of release and get the money in your client's pocket rather than having to have the sort of strain of a hearing, and the risk, the litigation risk in hearings is obviously high, particularly when relying on people to give witnesses. Obviously, QCAT encourages less legal representation, and for the parties to self-represent, which in itself causes its own risks and perhaps strain on the clients, although obviously you can get leave to appear if it's necessary. There is an appeal process from QCAT that's open to them, but obviously that's quite a significant step to take. So if you're not within QCAT, the best place to next go is the Magistrates Court, and in Queensland you can issue a claim to recover up to a debt to $150,000. So it's quite a large sum of money that's still sort of dealt with by the Magistrates Court. And obviously the Magistrates Court jurisdiction, whilst not as wide as District and Supreme, is now under the recent Act. It's very broad, so you can do things such as damages for breach of contract, equitable claims. The more complex declaratory relief, so say if you're talking about a resulting trust or trust monies or anything in that sort of realm, considered district or Supreme Court, and that's also just because of the experience of the judges presiding. But certainly we're talking about here today is pretty much debt claims. I think the Magistrates Court would be the right way to go for most of these type of matters. Proceedings can be commenced by way of a claim, or have to be commenced by way of a claim and statement of claim, to which the defendant will then have 28 days to respond. If they obviously don't respond, you can apply for default judgment. If they respond but the defence is weak or reasonably weak, you might even consider applying for summary judgment. I've just put there, be aware of a sliding court fee scale. So the higher the debt, the higher the court fee is. So it's not one fee right up to 150. There's also a slightly higher fee if your client is a corporation. So how will the debtor respond? Well, they're likely to throw in a defence. If they don't throw in a defence, as said before, you can get default judgment. That's a reasonably easy process. It's done on the papers. File a simple application and a supporting affidavit saying that no defence is being filed. Alternatively, if the defence is weak, and this is always a hard one to explain to clients because particularly in the Magistrates Court where there is probably a greater sympathy for parties, particularly if they're self-represented, the defence may certainly not be pleaded perfectly under the UCPR rules. But if there is a genuine ground of defence or as I say, reasonable prospect at trial, then summary judgment will be hard to get. The defence really needs to be quite frivolous or can't really hold up for you to be able to apply for summary judgment. But it is always worth considering, particularly if the defence really doesn't answer the pleading at all or really is just nonsensical. One thing to be careful of with summary judgment applications is often the court uses it as an opportunity to help the other side, so you do need to balance up those considerations. So if you're going there, and particularly also with strikeout applications, so it might be that part of the defence you want to strike out under the rules for not being sufficiently pleaded, but often judges, particularly as I said, if a debtor is self-represented, will maybe change the order to give them more time to file an amended pleading. So unfortunately, sometimes it's better to let people hang, so to speak, on their pleading down the track, rather than going through a process that in effect may help them in the long run. But again, it's a judgment call to make, and it's a hard one at times. If the defence is reasonable, then obviously your client is in, if they need to, it's not necessary a step, file a reply. The Magistrates Court will then normally direct for a compulsory directions hearing. They normally at this point sort of try to get the parties together, or otherwise they set out a timetable for the progress of the matter. This may or may not include a compulsory mediation. My view on mediations, being an insolvency lawyer, is you always learn something from them. You may not get a result, but I think they're always beneficial unless you really have a recalcitrant someone on the other side or someone who actually just really upsets your client and it's going to be more strain to them. But I think it's always a useful process. You understand the other side, what makes them tick, what are the big points for them. So always a good opportunity to use if you can. So if you do get a judgment, the client's always really excited at this point because there's this nice court judgment that says the other side owes them money. Unfortunately, it really means, I wouldn't say it means nothing, but it doesn't mean the money's coming into the bank account anytime soon. So what are your options then? I always serve, there's no compulsion or there's nothing under the rules that says you have to serve a judgment, but certainly it's always worth at that point to, again, like your letter of demand, enclose a copy of the sealed judgment to the debtor and say, look, judgment's been awarded, we're owed this money, pay within a certain amount of time, and again outline the consequences if they don't. The clear one, if it is an individual, is a bankruptcy notice. Bankruptcy notices can only be based on judgments, so that's often when we see people pay. People can put off the court process. It's very easy to put off the court process. A lot of people don't care. They're happy for default judgment to be entered into. Who cares? But it's when you serve the judgment and certainly threaten a bankruptcy notice. Bankruptcy notice have significant consequences for people who are perhaps running their own businesses or licenses, ability to get credit, affects all their other financial arrangements. So that threat of a bankruptcy notice is often when you start seeing money come your way. This is another good opportunity before you start to redo your searches. If you obviously have the means to do so, you might have done them right at the beginning, but there's often 6 or 12 months between commencing a proceeding and getting a judgment. So a good opportunity again to check, is your debtor still solvent? Are they bankrupt already? If it's a company, have they been wound up by someone else? Do your property searches. You might see that they start transferring assets to other parties, things to be aware of if you eventually do bankrupt them, because you'll be able to alert the trustee in bankruptcy to the fact that they've deliberately redirected their assets outside of the creditor's scope. So we do see a lot of that. Someone who owns 10 properties, as soon as judgment's been awarded against them, is suddenly a man or woman of straw. So that's why we recommend that there. Now, the problem is often is you just don't know whether someone has any assets. Often a debtor, all you know about them is what your client tells them, which is someone they met and they lent some money. You don't know what their job is. You don't know if they have any means. There is an ability in all states to compel people to go to an enforcement hearing where they can be asked questions such about their assets and about their income and about their debts. And on the basis of that information, if you don't already have it available to you, you can then apply for an enforcement warrant. Enforcement warrants, there are various ones. You can get them for garnish of wages. You can get them for sale and seizure of particular property, both real property. You can also get them for other assets. So you don't necessarily have to have an enforcement hearing. You can, if you know that the debtor owns a particular property, you can apply for an enforcement warrant in relation to certain property or perhaps for wages, but often the case you don't have that information available. And obviously your other option is, if you have a judgment and the person's an individual, is to serve a bankruptcy notice. If you have a judgment and the debtor is a company, you can serve a statutory demand. I should say statutory demands, and we'll talk more about them in a minute, can also be used without the need for a judgment. But bankruptcy cert notices, judgments you have to have a judgment before you can issue one of those. So statutory demands. The purpose and use of statutory demands. There is this, you probably all know, a very sort of famous line, which is statutory demands are not meant to be used as a way of recovering debts for court cases, but ironically that's really all they're really used for. So, but they're meant to be used as a way of winding up insolvent companies, because if you don't comply with a statutory demand, it is considered an act of insolvency under the Corporations Act, and the only way to sort of wind that back is at the winding up hearing to actually show that your company is solvent. I'm going to go into how to complete a statutory demand and supporting affidavit. They're highly technical documents and very easily to set aside, same as bankruptcy notice. Quick moment on how to effect proper service, how they can be challenged, and acting for a creditor in an application to set aside a statutory demand. So the key point, there is a prescribed form, Form 509H, and it's found in Schedule 2 of the Corporations Act regs. You have to, as I said before, they are particularly technical, so everything needs to be pretty accurate. So sufficient details so the debtor company can't be confused. I know it sounds silly, but it has to be all right. Right ACN, right description of the company. Some minor deficiencies, there are cases that will allow minor deficiencies to pass, but generally, you can't really have anything that is a little bit confusing, particularly around the nature of the debt owed. So if it is invoices, you really want to particularise the number of the invoice, the amount and the total, and that can all be set out in the demand. Foreign currency debts are permitted. I don't know if that comes up a lot, but you are allowed to claim a demand in another currency. But again, be really careful that the terms of the agreement, it's not just that perhaps the client wants to be paid in a certain currency. The terms of the agreement must have always contemplated that the payment and the debt is owed in that particular currency. Now, you do need a supporting affidavit. Now, this isn't required if there is a judgment. So if there is a judgment, you don't need a supporting affidavit. But if you don't have a judgment, yes, you do need an affidavit. It must match the description of the debt in the statutory demand and by a person with knowledge of the debt. Obviously, generally this would be your client. And the timing, the statutory demand must be dated the same date as the supporting affidavit. So you can't have, sort of unusual in court, you can get someone to sign an affidavit sort of 2 weeks before and then put it in. You have to have them both simultaneous. So tips for completing a statutory demand: make sure you confirm the ACN, sufficient particulars of a debt, signed by a solicitor or someone else with the capacity, affidavit sworn the same date. Personal knowledge, you actually do need to say that that person's had access to the books and records or has access to the information available. So your client really needs to be the one with that first-hand knowledge or someone else with that first-hand knowledge. Now, in the affidavit, it has to say the debt is due and payable, and there is no genuine dispute as to the amount of debt. This is a pretty low threshold, so if there is what you consider some pretty easy arguments perhaps on the part of the debtor to raise, it perhaps may not be the best statutory demand, may not be the best way to go for your client. So service, very important that, again, stat demands can be easily set aside if service isn't effected in the proper way. It has to be done on the registered office if you're going under 109X. So you've got to have the same, it's got to be the right address at the right time of service. You've got to leave or post it to the registered office, must place documents in an envelope. You can't leave it in an out tray, all the usual sort of things about service. You can't get a third party to post it because you're going to need direct evidence that it was actually posted. Registered post is not service. Just things to be very much aware of. The best way is to carry it or to leave it at the registered office to be sure. So how will the debtor respond? They've got 21 days to act. This is a strict time frame. This is not one of the good old court frames that can be easily extended. So the debtor has to put in a application to set it aside within 21 days of service. They must file and serve an application and a supporting affidavit, and they have to serve it equally back on your client appropriately. There has to be a genuine dispute. It is a very low threshold. So if your client perhaps is saying, 10 invoices, I'm owed this, but then the other side have a dispute about whether the work was actually conducted, and you've seen letters that clearly set out perhaps that your client didn't do the work to the standard that they were meant to under the terms of the agreement, and your client might be absolutely adamant, but if you've seen correspondence or you think that it'd be pretty easy for the other side to equally come up with a dispute the fact that perhaps your client didn't do the work or the work was shoddy or anything like that, then it's probably going to be a genuine dispute, which means that the stat demand will be set aside and your client would have to pay costs in those circumstances. So statutory demands are a serious beast, and therefore they're quite easy to set aside. Again, offsetting claim. Offsetting claims aren't fatal. So if there's still an amount owing or an adjustment made, the court will make that adjustment. They make that adjustment to stat demand and say the amount's due and owing. But obviously, if the set off or the offsetting, cancels out your client's debt, then you're in serious problem. And again, there are other grounds for setting aside stat demand, some defect that causes substantial injustice or other reason. And that goes back to getting the form quite correct. If there's something misleading or the debt not being described properly in the stat demand, it might be set aside as a matter of form rather than under the genuine dispute heading. That's, yep, I've just got a question about the how much money needs to be owing to issue a stat demand. It is $5,000. I will say bankruptcy used to be lower as well, but they've changed that now. So this snazzy little overly Ashurst coloured slide just puts a summary in about stat demand. So they're effective means of creating a statutory presumption of insolvency and getting paid. So as I said before, there is this sort of line that they're not a debt collection tool. They're really about creating that assumption of insolvency. So if someone doesn't comply with a statutory demand, you're deemed insolvent under the Act, and then your client can take the step to make an application to wind up the company. At that application to wind up, the debtor can't start bringing up arguments around the statutory demand. The only sort of option for them is to then dispute the actual winding up on the grounds they're solvent. Must only be issued where creditor has intention of winding up if payment is not received. That's the kind of ethos behind them. I'm not saying often clients haven't sort of thought about the second step, But obviously it's a natural second step. If they don't pay the stat demand, you'd want the company to be wound up. You'd get it in the hands of a liquidator, and then they can start obviously realising assets, and hopefully your client will then get a dividend in the liquidation. Payments received likely to be deemed preferences. I'm probably won't go in. That's a bit of a hangover from another slide. So bankruptcy notices. Again, purpose and use. So we're now in the Federal Court and Federal Magistrates Court only. How to complete a bankruptcy notice, how to effect proper service, challenging a bankruptcy notice, and acting for a creditor. Again, similar to statutory demand, they're a prescribed form, bankruptcy notices. I'll just put up where you can find it, Form 4. Strict compliance is necessary. You've got to attach a sealed copy of the judgment bearing the original stamp of the court, and the judgment must not be stayed. Obviously, also, if a judgment is on appeal, it's probably going to be quite easy for the debtor to set aside that bankruptcy notice, or at least apply to stay the effect of the bankruptcy notice. If there is a joint, often you might have a judgment against multiple debtors, so 2 people might have owed your client money, so you can actually put 2 people on a bankruptcy notice or issue 2 separate bankruptcy notices. Again, foreign currency is permitted. So once you prepare a bankruptcy notice, it isn't filed at a court. You file it at ITSA, or what's now known as ABSA. Old reference there. Once issued by ABSA, they process it, they will send you back a sealed copy. So you can do that by post. You can send 3 bankruptcy notices into ABSA, they'll register it, seal it, and it comes back to you for service. It will also be noted against that person's personal insolvency index that a bankruptcy notice has been issued against them. Again, it's a way of notifying the world that perhaps there is matters on foot against that person. So if you don't, no supporting affidavit necessary for this one because it's a judgment. Now, personal service isn't required but recommended. See bankruptcy notice, bankruptcy rule 15. And this has been a bit of the courts haven't really been quite clear on this. We always say personal service because it is, again, very easy for someone to say that the bankruptcy notice didn't otherwise come to their attention. So, personal service obviously is hard at times, but if you can get it done. The courts actually, under the Federal Mags Court now, have a really good sort of online applications for substituted service now, and they're dealing with those a lot quicker than when I first started practicing insolvency. So, you can put together an affidavit if you can't get hold of someone, but you know that they answer emails, they answer texts. We have served by Facebook in Victoria, or at least we got an order saying that we could post a notice on someone's Facebook wall saying that a bankruptcy notice would be issued to them at the following address as a way of notification. So there are they're good cases to look up. There are some quite creative ways now of serving someone outside of the personal service realm. But I certainly would hesitate to use those methods without actually getting an order for substituted service. Instructor process server, obviously, if you can and you have the means to do so, and make sure that they get to the person and that there is a good affidavit of service. You have to serve within 6 months of issue. So if it takes you longer than 6 months to find the person or to get that sub-service order, your bankruptcy notice is no longer valid. Again, like the stat demand, the debtor has 21 days to act. They can file an application to extend the time of compliance, and a typical one when they do that is that they are actually appealing the judgment upon which the bankruptcy notice rests upon, and perhaps that appeal is coming up for hearing within, say, a month. So in those circumstances, the judges are often quite sympathetic and say, well, I'm going to sort of extend the time for the bankruptcy notice to take effect until after the determination of that hearing. Again, the other side, if it is based on perhaps a default judgment or any other type of judgment, it's not enough for the debtor just to say, oh, yeah, I disagree with that. A judgment should never have been entered. Yeah, I disagree with all that. They can't just say that. They must have taken steps to set aside the judgment. If they haven't filed an application, generally that's what most judges expect. They certainly need to serve strong affidavit evidence that sets out that there is a genuine ground to actually do set aside the judgment. There will be, they just can't say, oh, I disagree. And certainly they need to have taken proactive steps. Otherwise, they risk losing that application to set aside or to extend the time for compliance with the bankruptcy notice. Again, there are the option of counterclaim, set off and cross demand. Again, the court is going to be pretty, again, they're not going to go behind the judgment. They have the ability to do so, but they're going to be reluctant to do so without proper affidavit evidence on behalf of the debtor. And again, there is the ability to set aside a bankruptcy notice upon some other ground. Again, defects in bankruptcy notices, as I've said there, minor errors do not invalidate, but substantive errors that lead to injustice will. So it may sound silly, but we certainly had this accidentally ending, adding an extra 0 to the bankruptcy notice. It might have been for 10,000, but you accidentally wrote 100,000. Their argument would be, oh, I panicked, I couldn't comply, I couldn't comply with the notice and I didn't want to spend money, this misled me, etc., etc. So quick summary, requires a judgment debt. Bankruptcy notice, very effective means of getting paid, and it's because of the implications of non-compliance with the bankruptcy notice is obviously that then you can apply for a sequestration or a bankruptcy order against a person, particularly, as I said before, anyone that holds licenses and it will trigger default provisions in someone's home loan mortgages. It does really affect a person's financial state. Again, I would keep an eye, we talked about the importance of doing searches. Often when people are served with the bankruptcy notice, they would rather than put themselves into bankruptcy than wait for you to bankrupt them. And that's also so they can use the options under which AFSA have of a Part 9 or a Part 10. These are sort of voluntary bankruptcy agreements where a debtor agrees with its creditors as to how to distribute its assets or comes to an agreement in a voluntary way. That gives the debtor a greater level of control. So unfortunately, probably not say unfortunately, but often is the case, you've gone through a full Magistrates Court hearing, you've got your judgment, you've issued your bankruptcy notice, but all of a sudden the debtor bankrupts themselves. It might take a bit of sort of satisfaction out of the proceeding, but often people do so they have that greater level of control. The other thing people would rather is appoint their own trustee, and that's what sort of doing a Part 10 or a Part 9 allows them to do so. When if otherwise it's your client who's bankrupting them, you get the option then of choosing your own trustee. So a debtor may not want a sort of third-party trustee interfering in their affairs, although all trustees have similar duties, but there is that element of control. So they're all the really, I guess, formal processes. What are your other alternatives? Now, the first one is that you're all familiar with is obviously ADR. So that's, any type of alternative dispute resolution, whether it's a conciliation, a mediation, a without prejudice meeting. And I'd fall into that without prejudice offers. Is there a point where you're dealing with the debtor and you send them an early offer and say, look, we feel like we have a strong case. We've got, we enclose a draft Magistrates Court proceeding. We're all ready to go. However, to avoid all this, we're happy to accept, say, 80% of the debt paid within X period of time. Certainly, I think there's good things about entering sort of those type of agreements, particularly if there's a quick way of getting judgment against them. So we'll talk about this more with deeds of release. You might compromise your debt, say, look, we agree that you'll pay 80%, you'll pay 50% now and 50% later. If you don't pay first amount or the second amount, we get a right to apply for judgment straight away. And that can give your client sort of a good level of comfort, because whilst they are betting, I guess, that the other side will pay, the way of then getting judgment is shortcutted. So you've got then a right to instantly get judgment instead of having to commence proceedings if you draft your deed of release in that way and the other side agrees. The other option is debt collection agency. They act in various ways. A lot of them you actually sell the debt to them. So they pay a price for it and then it's out of your hands. So it no longer is your client's debt. They just get the money for it from the debt collection agency. Obviously, debt collection agencies don't pay huge amounts for these type of debts, but it's a way. It is always worth exploring to see if you can get your client quick money. But the debt collecting agency will need to see sort of the documentation, understand the nature of the debt before they purchase it, and they'll value the debt based on that. Alternatively, you can just outsource it to a debt collection agency, and they normally take a commission as to perhaps the recovery. Some of them just do a fee up front and say, look, this is what, this much chasing gets you, this is how much it costs. There's a lot of them do that no recovery, no fee. So they'll take them on if there's no result. Those ones are good, but always check the fine prints, because often if they do recover, obviously they do often take a pretty big whack of the recovery amount. But they're not as dodgy. They are heavily regulated, but I'd still say really check out their reputation. And there is an element of loss of control of the process. Obviously, the other option, and this is probably for more larger debts, is considering assigning or selling the debt to a third party. So alternatively to debt collection, there are people who buy legal claims and buy debts. It's becoming a little bit more in the Australian market, certainly nowhere near as much as it is in the UK market, but it's still an option to consider. And I'll just lastly, with the debt collection agencies, they're under some pretty strict laws about prohibition of the use of physical force, undue harassment and coercion. They can't use misleading or deceptive conduct. They can't threaten things that aren't true. And there's a pretty strong prohibition of unconscionable conduct. So they are heavily regulated, and it's important for your clients to understand the limits to what debt collection agencies can do. There are laws about when they can contact people within certain hours. They can't contact them late at night, frequency of contact. So often we have pro bono clients saying, well, why isn't the debt collector agency calling them on the hour every hour? Well, the debt collection agency is under some pretty strict rules. So if you do get an agreement settled, really important to reduce the terms to writing. It may be that your client actually strikes a deal outside of perhaps your representation. Certainly happens to us with very sophisticated clients as well. But your client might ring up and, oh, look, he rang me up last night and yeah, he's going to pay me $5,000. And yeah, it's not the $12,000 I'm owed, but $5,000. If you can intervene, it's always a good thing to say, well, hang on, before you, let's put that in writing, just to give your client some security. Obviously, it's up to the other side whether they will sign something, but it's always better to get, even if it is just a simple agreement, it's better than nothing, because then you can then sue on the agreement or the deed of settlement, or even if it's a terms of settlement, rather than having to go back to the primary dispute about the debt. Certainly if the dispute is already subject to illegal proceedings, you've already commenced proceedings, and then your clients do a deal with each other, even more important to prepare some written terms of settlement. Now, there's different considerations applied depending on whether you're acting for a plaintiff or defendant, or in this case, a debtor or a creditor. So the scope or width of release, is it a one-way release? Are you just going to release them from the debt? Are there other claims, particularly if it was a consumer-trader relationship? You want to make sure or if there was a sort of a two tradies, there might have been a kind of a mutual work being done both ways. In that circumstance, you probably want a mutual release as against your client as well, so there's no sort of lingering claims either way. Again, we talked about if someone does default under agreement, is there going to be sort of what I call a guillotine order? So there's a way then to apply for summary judgment straight away, and the other side is then prevented from raising a defence. That's sort of like your dream term in an agreement, and always worth asking for. The other option is you actually agree to get judgment first, and the judgment is then held in escrow pending default, although it's going to be always a hard sell, that one, but certainly it is good to perhaps get a quick way to judgment drafted in there if someone does default. Your client may wish to discontinue proceedings rather than having them completely dismiss. Discontinuing them means you have an ability to re-enliven them if someone defaults under a deed of settlement versus having to recommence the proceedings. But I think the main thing is to consider with this type of what we're talking about today is definitely releases. Make sure that if there's any lingering claims against your client, set off counterclaim that you release your client, as well as getting a release of the debtor if they pay. So I think that brings us to the end. I know that was a bit of a whirlwind tour through Debt Collection 101. If there's any other questions, very happy to have a discussion.
Meredith, thank you for an incredibly practical tour through the wonderful world of helping clients recover debts. A reminder out there, folks, that there are a couple of ways you can ask questions. You can press that button that looks like a hand on your control panel, and we'll unmute your microphone and you can ask a question that way. The other way that you can ask a question is to type a question into the questions box. While I'm giving people a couple of minutes to do that, Meredith, I just quickly ask, you kind of mentioned in passing a reminder before issuing a letter of demand. In my practice, I was always pretty keen to pick up the phone to the other side and say, hi, I'm James, I'm Bob's lawyer. Bob has a lawyer now, pay him his money. And that generally kind of shook the tree pretty quickly. Wonder if you've got any if there's anything that we should be concerned about in what you've kind of almost colloquially called there reminders.
Being concerned about in terms of,
stuff we shouldn't be saying.
No. Oh, look.
How we should approach that?
Yeah, no, I think what you said is obviously have the details of the debt. Do that homework before you start doing formal reminders. I mean, your client probably has already, in their own perhaps imperfect way, reminded the other side. So this is, I think, do your homework first with your debt. Make sure you've got the clear understanding of how and when the debt was owed. But no problem at all approaching the debtor. And there's a good opportunity to say, oh, look, I'm ringing on behalf of X person. Do you have legal representation as well? Check with them, or is there someone in your accounts department? If it is a company, it may not be the person that your client's been talking to that actually is the one who pays, especially a husband-wife is the classic one. You get the kind of, oh, sorry, I thought that had already been paid. My wife deals with that. They'll pass them on to the wife. So I think there is, and 1 or 2 reminders. There's no harm in that before you issue the letter of demand.
Another question has come through. Fairly specific, I suspect, from this question. So I might just get you to read that out.
Yeah, we've got, and this goes to talking about types of enforcement orders you can get. If the debtor owns rental property, can enforcement orders stretch to say rental payments can be used to satisfy debts? Look, to be frank, I actually don't know if the answer to that particular sort of question, but what I can say that if they own a rental property, that would be considered an asset. And if you're doing an enforcement hearing, they would be required to give, and you can obviously ask for this, statements of assets and liabilities. So that income would be factored into the order that the judge might make as part of a repayment plan, or alternatively as a redirection. So again, the garnishing. So it may be not that the order is directly related to the rental repayment received, but that would factor into the order the court would make in relation to the debtor's assets. That hopefully answer your question, Andrew. That was a good one.
Let's get another question. Where is there overlap in the jurisdiction between QCAT and the Magistrates Court, and what are the factors that you might consider?
Yeah, I think the overlap is probably again in the consumer sort of world, as that question before came in with the sort of sole trader, your client being a tradie and being owed a debt. Again, that's when it's a sort of a matter of, do we go down this route or not? I must admit, I'm more inclined, if there's any complexity at all, to go the Magistrates Court. If there isn't a written agreement, if there is a written agreement of any, I think it's easier to go to QCAT, because that was the whole small claims world, which used to be in the Magistrates Court. So if there is a loan, a very simple IOU, and they wrote it, it might be on the back of a coaster and there might be 5 paragraphs, but if it still sort of says this amount of owed, this is when it's paid, this is when it's back, then I would go QCAT. But any sort of level of complexity in terms of evidentiary complexity, or perhaps the claim might actually be more likely as it morphs into being a claim for damages, is to start off in the Mags Court. That might be a bit of a nebulous answer, but
we have run a couple of minutes over, and it doesn't look like there's any other questions coming through. So on behalf of people clapping and cheering wildly at computer screens across Queensland, can I thank Meredith for, as I said before, what was a really practical and useful webinar that yeah, will come in handy lots in the work that we do in community legal centres. And I'm only echoing what some of the feedback that's coming through in the questions and chat on the GoToWebinar. So clearly you guys got a lot from it as well. Meredith, thank you very much. Folks, thank you all for tuning in, and we look forward to catching up with you soon. Bye-bye.